takes court order to approve any transfer of assets to an heir. And as long as there's any kind of bills outstanding, the court may be rather reluctant to allow anything to go out for fear there won't be enough to pay those bills. The greatest disadvantage of probate, as we've got up here on the screen, is that probate fees. The national average for probate fees, or that's attorney fees, is 6.4%. And I maintain that I think living trusts are as much or a greater need for small estates than large estates because of that probate expense. It'll rival the funeral expense to the estate when it comes time to pay the attorney if all the assets go through the probate process. And the problem with a small estate is that they don't have a lot of dollars. And so there can be competition amongst the different creditors for the remaining dollars of the estate. If they've had medical debts and funeral expenses and attorney fees and credit card debt and mortgages and so forth, sometimes there may not be enough dollars to go around. And it can be very important to figure out ways to reduce some of those expenses. And one of the first things we can do is put that estate, even a small estate, through a living trust, and it eliminates the need for probate administration. Living trust at death avoids probate. That's a tremendous advantage. Therefore, a couple things result. One, they're considered incontestable in the distribution of their assets. And it's not unusual to put a clause in a trust, contrary to the probate code, that says if somebody contests this, they will forfeit their share. Now, the law really does not like forfeiture of an individual share, but they can have a number of other things done to them in addition to losing or forfeiting their share. They can have all the expenses charged to their share instead of to the trust as a whole. Trusts can be are privately run by the family, and the family's control is continuous through the event of death. The family stays in control if the estate holder appoints adult family members, usually children, with some ability and responsibility to be successor trustees. They will continue to manage the operation of the estate within the trust, and there's very little outside expense. They can hire attorneys, they can hire accountants to give them advice. That may be a few hours here, maybe a few hours there, but they don't have to shell out 6 and 7 and 8% of the estate to have it administered. The administration can be immediate. There doesn't have to be a 6-month or a 1-year or 2-year delay. I've actually participated in cases where they knew that mother was dying. They knew that she wasn't going to make it beyond Thursday. And so the daughters were all prepared. They had the bills pretty much paid in advance. As successor trustees, they took over. And they had the funeral on the weekend and could distribute the balance of the assets and all return to their homes within a matter of days. So it's possible to have immediate administration. Trusts are almost a necessity. If an individual owns property in more than one state, and I mean real property. If they own real estate, say in Florida, and then they own it in a state somewhere up north in the United States or somewhere else on the globe, trusts are almost critical in being able to avoid double probate. Probate both in the domicile state and then ancillary probate jurisdiction to hand over the title in the other state that the person owned the real estate. It's almost essential that the individual have a trust which avoids probate in both places. Living trusts were created, I told you, centuries ago. Prior to the Protestant Reformation, probate was handled by the ecclesiastical courts of the Roman Church. And it was part of canon law. In fact, there's still a segment of canon law that deals with probate. And it was part of all of Europe when the Christian Church was of major influence prior to the Reformation throughout Europe. One of the results of the Reformation is that probate, and the reason why the church became the probate administrator was because usually the only people in town that knew how to read and write were local clergy. And therefore, they were the only ones capable of keeping records, and the records of which kids belonged to which parents and grandparents were those baptismal records that they kept in the basement of the big basilica. So they naturally became the librarians and record keepers of the communities, and therefore they became the natural for probate administration and figuring out who ought to get what. Well, the problem arose in the Middle Ages, where the church started requiring a contribution to the church called a mortmain contribution, Every time someone died, it started out at 10% of every dollar and rose its way up to about 25% out of every dollar. And people started to be in rebellion about that. So in England, they adopted the Statute of Trusts. And when Henry VIII broke from Rome, he reestablished a probate system within the Chancery, the courts of equity. Britain had an excellent jurisprudential system, and he reestablished it there away from the ecclesiastical courts. That tended to spread through Europe, where principalities and governments of various types took over that probate function, and it became a secular function. And as a result of that, trusts were adopted. In England created it. They were the first to kind of rebel from the probate system. Well, England finds North America and settles, and all those laws come over on the boat to the United States, including trust law and probate law. And they go from the East Coast colonies all the way across the United States and heavily influence the evolution of law in the United States. They're an underpinning of that growth. And trust law is recognized in every state in the Union. Trust is not something that you can see or smell or feel or hold in your hand. A trust is simply a thing we lawyers create on a piece of paper. It's called a legal fiction we create on a piece of paper called a trust agreement. And we create this imaginary entity to own stuff separate from the person who sets it up and separate from the beneficiaries of it ultimately. And we're going to appoint an administrator to run and handle those assets when they're owned by this imaginary thing called a trust. In the trust agreement, the ones we're talking about are revocable. They're changeable by the estate holder, but in there we have appointed a settlor. That's the estate holder, and oftentimes the estate holder's spouse. But they have the power to rewrite and change provisions within the document. The settlor has power to reappoint a trustee, to change trustees if they wish. And they have the right not only to put assets in the trust, but to take assets out if they so wish. They can access principal and income at their own discretion. All right? And they can put all types of terms and conditions in the trust that when they die, they want their assets to go to their kids. So if we've got one child who's on drugs, and we've got another child who's disabled, and another child who owns part of the family business, we can have different provisions and different terms and conditions in there for each of those different children. If we have a child with several grandchildren and they pass away, we can have provisions in there for those grandchildren to participate in that particular child's share. And if they're too young, we can hold it in trust until they get older. We can make income available for the young people who are incapacitated as they need it or to supplement their needs. And when they get old enough, we can transfer assets to them. We can hold it and use it for their education or their health or their welfare. And then we can ultimately give it to them when they reach older ages. So there's a whole deal of flexibility in the planning and in describing the estate holder's intentions and being sure those intentions are carried out without opportunity to contest those intentions. We have to retitle the assets. The trust is treated as a separate owner, so what we're going to do is retitle the house and the bank account and the shares of stock and the mutual fund account. All these different things are going to be retitled from John Doe to the John Doe Trust as owner by John Doe Trustee. John Doe will run and operate those assets the way he always has, except that now when he dies it's owned by a trust. The owner doesn't immediately quit. If we have it in John Doe, it means it's John Doe's estate, and as soon as John Doe dies, that owner no longer exists. Theory is it immediately belonged to somebody else. Well, we got to go through this process to figure out who it is, as opposed to leaving this document that explains who it is, having a successor trustee, adult children usually, who step in and take over and can continue the trust operation when John Doe dies. Trusts don't die when the estate holder dies. They continue to manage the assets through a successor trustee beyond the estate holder's death. So if those heirs meet those terms and conditions specific to each one of them within the trust, they have a right to go to the trustee and say, see, I've met the terms and conditions, here they are, and I am entitled to take my share of the trust without having to go through court approval or a court process.